And who do I have here?
Donald McMahon, man.
Okay, you need to take your hands out of your pockets, please. And you?
Maureen Jesk.
Okay. So, folks, where are we on this case?
I am the landlord, and in October, I had served with everybody raises on their rent, and they had notified me they weren't going to be able to, and I had done the paperwork, served with a notice to leave, and then we made an agreement. I went along with his agreement, and we decided, I gave him everything he wanted, everything he asked for, and we signed it legally. I gave him his money and then he tried to pay me for December to stay, and he was supposed to be gone December 1st. And December 1st, I had new tenants starting to move in, and now they can't. And now he's still staying there. He still will not leave. So I filed again to see you because he won't leave the premises.
Right away, this case sets the tone for a classic landlord-tenant standoff. The landlord believes a legally binding agreement was signed, money exchanged, and a firm move-out date established. From her perspective, this isn't confusion, it's breach. Meanwhile, the tenant is still occupying the unit, blocking new renters and costing her real money. This is where housing court gets brutally practical. It doesn't care who feels wronged. It cares about timelines, paperwork, and possession. And notice, the judge hasn't ruled yet. He's listening for one thing only: who legally has the right to stay right now. Question for you: if you were the landlord, would you have trusted a verbal agreement this long?
And I don't know.
The place where we're moving to, we had setbacks because they were doing improvements. They were doing upgrades. And it was supposed to be done last month, and the upgrades are going to be done this month. You have a lot of tools, and it's a business to move out of there. So we have to have a place to go in order to move everything. It's, and our original rent, our lease agreement is right here.
You have the original copy. Excuse me.
Her doctored version is this one here. So our lease agreement, she stated when we asked her about this.
This moment is critical. The judge cuts through everything and drops the legal bombshell. There's no active lease. That single fact reshapes the entire case. In most jurisdictions, once a lease expires, the tenant becomes month-to-month, meaning far fewer protections. All the past plumbing work, promises, and misunderstandings. Emotionally important, but legally secondary. This is why judges constantly interrupt rambling explanations. The law doesn't run on stories, it runs on status. And right here, the tenant's position weakens significantly. Ask yourself, how many people think they're protected just because that's what we agreed to?
And the way she spelled it out, she said we could stay there as long as we wanted. Okay, I did a bunch of plumbing work for this unit in order for it to be even rented. I got pictures of that. I got receipts for everything. We carried her for a year. In the
Hold on a moment, folks. But right now, there is no lease agreement.
There is no lease.
Listen to my question, people. There is no lease agreement right now. Okay, so now my question becomes this. Okay. You thought they were going to be out at a certain point. They're not out.
December 1st we agreed on it. We probably signed all the
that's why does everybody want to expand on my question?
I apologize. Yes. I'm tired. It's been a long day.
Tell me about it. And you had a tenant ready to move in. They didn't move in because okay.
I'm sorry, Your Honor. Go ahead. I'll shut up.
Okay. So is that tenant now lost? They're not there, right? They're waiting. Okay. The unit you guys were going to move, but the place you're moving into needs to have work done on it so you can move into the unit.
Yes, sir. They're upgrades and they're just finishing.
Okay. I heard you the first time. All right. I get it. When people tell me, if I don't hear something, I'll ask. So when will the upgrades be done?
They'll be done this month.
This is the courtroom reality check most people don't expect. Even when a landlord wins, eviction is not instant. The judge carefully explains the domino effect: judgment, waiting periods, writs, sheriff service, and final enforcement. Best case scenario, still weeks. Worst case, months. This is why judges often push for cooperation. It saves time, money, and sanity. And notice how the judge is already thinking ahead, calculating dates out loud. He's not just ruling, he's managing damage. This is where the system feels slow, but it's designed to avoid chaos. Would you have the patience to wait this long if rent money was your livelihood?
So if the upgrades are done, what day can you be out?
By the end of this month.
Okay. Now, Miss Avey, will the tenants that are going to move in, can they wait till February 1st to move?
They have been waiting 3 months now, and I'm
I didn't ask
afraid
you
I'm
that.
gonna lose them.
I didn't ask you that. Can they wait or can they not?
They cannot wait.
Okay, have they told you that?
Yes, because they planned on December 1st getting in because I had told them it was arranged.
All right. So but here's the problem. Okay, just so that we know. If I give you your judgment today for possession, right? And I'm just going to boil this down to the practicalities of it all. If I give you your judgment today, you can't do anything to move them out of the premises. You're going to have to file other paperwork to move them out of the premises, but you won't be able to do that until the 16th of January, right?
That's what I did the second time that you should have the second notice that I filed, because I filed twice now.
This is the turning point. The landlord realizes that pushing forward legally could actually cost her more time. Instead of forcing the system, she pivots to the fastest exit strategy, negotiation under the court's supervision. Judges love this because it reduces enforcement work and keeps emotions from boiling over. And look at how the judge subtly pressures both sides. Move voluntarily or the law moves for you, and that never ends gently. This moment shows courtroom strategy in real time. Sometimes winning isn't about force, it's about timing. Would you settle here or push for full enforcement on principle?
Please listen.
Yes, I'm trying to listen to what you're
All right.
asking me.
Let's say I find in your favor today,
Yes.
okay? And if I find in your favor today, they get 10 days to move out, okay?
Yep.
But if they don't move on that date, then you have to file another piece of paper with the court for a writ of eviction. That has to get to me, I then have to sign it. Let's say that happens quickly, and let's say I even sign it that day. Then I'm going to go to the sheriff's department, or whoever has this particular area, to serve, the court officer to serve. Once it's served on them,
That's what I,
by my
okay. I'm listening.
order, they're going to have 72 hours from the time it gets posted. So let's say everything happens as quickly as we possibly can. I'm now at January 22nd. Then you have to set a time. You have to get people to move them out.
Okay.
Let's say you got that all set up. You're probably going to be at January 25th, 26th.
I understand. I see what you're saying.
So, and by the way, it'll be January 25th, 26th, and you've had to spend money. Granted, you can get some of that money back from him, but you've had to spend money in aggravation to do everything.
I'm losing money. It wouldn't, Honor, is what you're saying, if we, instead of filing and you do this all today.
There it is, the ruling. Judgment for possession granted with a firm writ date, January 25th. This is the judge balancing fairness with enforcement. The tenant gets time but not uncertainty. And notice the warning that follows: if eviction proceeds, property loss becomes a real risk. That's not a threat, that's procedure. Once officers are involved, personal control disappears fast. The judge is practically begging them to avoid that outcome. This is housing court at its most human, strict, tired, and deeply practical. Comment below, do you think this was a fair compromise?
Will they go? I mean, I just want them to,
Go ahead.
excuse me.
I don't know.
Okay, well,
I
that's
have
what I'm
no
asking.
idea. It's part of what I have to do here. I issue orders, people don't follow them, then I enforce the orders.
Well, that'd be the second time they've told me they were going to and they didn't. So that's why I'm asking. I'm 3 months now behind. I mean, I live on the money that comes into there to pay for all the repairs and stuff I do and keeping up the place.
Okay, what do you want me to do?
Whatever is the quickest and the easiest way to, let's do it. If they'll be out,
What's the soonest? I heard what you told me. What's the soonest you guys can be out? I mean, even if you have to do sort of a temporary move to another, I mean, I know that's not ideal, but
Well, we were looking at, we would need the rest of this month. We would be out. That's what I was asking for.
I understand that. But I'm asking a different question. When's the soonest you can be out?
Well, 25th.
Given what I said, man, Miss Amy, will the 25th work?
yes.
See how easy that is? People just answer my questions. I've been doing this for a while. Some days like today, I'm thinking too long. Here's what I'm going to do. I'm going to grant a judgment finding no tribal issue after a hearing. I'm going to grant a judgment for possession. But the writ date, that means the date they have to move, will be January 25th, 2024. Okay? Now, I'm just going to say to both of you, if you can get yourselves out, just do it. Because if more money has to be spent to evict, ultimately that's going to come back on you. And that, you don't want that. If everything operates quickly, then what's going to actually end up happening is the stuff that you have that you got to move, you might lose. I mean, if she gets in there and does it. So that's the best thing to do, is to just do that. I realize there's probably a lot of water that's passed under the bridge between the two of you. But if what can happen is, if it's just solely regarding this issue, that you can kind of talk to each other civilly about what needs to happen, it's a savings on both sides of this whole thing.
That's what
All
we
right.
tried to do. That's what I thought we did.
You know what, ma'am? I was just talking.
I know you're
and
tired. I don't
No, I'm not tired. I can do this all day and night.
I'm just
long.
thinking all
But
the
as
money
long as people stop interrupting me and listen.
I know. I apologize. I thought,
You need to submit a judgment to the court, and then I'll sign it. Any questions you guys have?
No.
Thank you very much. Everybody have a great evening.
thank you.
How are you?
I don't know.
Looking for every great recommendation I can receive from you today, sir. I have been in a very horrible assaultive position.
Okay, let me
left your...
hold on a second.
Okay.
State your name for the record.
Danette Mellick.
Okay, go ahead, Ms. Miller.
Well, I entered your courtroom honorably last year at this time. I came in as a plaintiff.
Okay.
And when I swore in, I gave some information about one company, Akram Rashid, merging with a new owner. At that time, I, the customer, was not given the respect, nor any other tenant in my building, underneath the laws to meet this person as a consumer. It is of complete responsibility for a new company to acquire the permission of the tenant, where money is concerned, to enter a good consumer relationship. This did not happen. Time proceeded, and this maintenance company decided to enter person's property with no permission, started to manipulate them, stealing possessions, stealing automobiles.
Okay, ma'am, can I ask you something?
Sure.
Is this your motion to set aside the judgment?
Well, I did set it aside, and we met that agreement. An attorney named Kevin Callahan sat in a court with me as a plaintiff. According to the law, there are no attorneys allowed. So I tried to motion in at the end of August because I recognized.
Hold on, no attorneys allowed where?
When I first met with you, Your Honor, I went into a small claims, and I was underneath the impression through the courses of the law that there were no attorneys allowed in a small claim. So something kind of got jangled up. I presented charges.
Ma'am, hold on.
Okay.
Okay, because I want to make sure that I've got everything in front of me. Was there a small claims case?
Yes. And at that time, we made an agreement.
Go ahead.
That after August, which was Akram Rashid's current lease, that there were not supposed to be any changes to, yet that wasn't the case. I would be on a month to month. I raised my right hand. Kevin Callahan, yourself, and I made that agreement. He swore to me, my mother, which then reported it to my banks. I reported it to my private attorneys in New York City that managed my work. And I contacted the courts. I talked to him verbally over the phone from his office in St. Clair Shores. And he stated to me that I swear, you're going to receive that sheet of paper. I waited and I waited and I waited. Spring and summer came to fruition, and I called the courts. It's getting, later in the year. Where's the sheet of paper? It was as easy as that. There was no failure of me to make the payment. I still have the finances set aside. I feel like they are trying to retaliate against me because I've continued to make reports, which is my sole discretion. I have the right to do that. Between the Michigan State Police that were called on numerous occasions by other.
Ma'am, I'm going to have to stop you because I'm not clear what you're talking.
Well, I think that there's a position here where there's charges that he wanted to dismiss, but because he did not fulfill the obligation that he promised me, by August, I was being manipulated, and they're not following through with their original agreement.
Manipulated by whom?
I, yourself, and Callahan, last January coming into February. We sat in the Zoom conference. I presented the paperwork that was unorthodox.
Judge, if I may, I have information on this.
And this change of ownership will not affect your lease agreement. She put unless otherwise indicated in your current signed lease. Well, unless otherwise means I can't do what I'm claiming I'm going to do. She broke these laws.
She being whom?
E.J. Elizabeth Jefferson, who claimed to be a property manager that...
This second case escalates fast and emotionally. The key legal issue here is default judgment. Miss Malik missed court dates, and in civil court that alone can end your case. No conspiracy required. Once a default is entered, undoing it requires very specific legal grounds. Confusion and frustration usually aren't enough. The attorney's tone shifts from procedural to defensive, signaling how serious these allegations have become. Courts tolerate passion, but not disorder. And when repeated interruptions happen, credibility erodes fast. This moment shows a hard truth. The court can only rule on what's properly filed and timely. If you miss your hearing, should the system wait for you?
No one had ever met. There is no legible address. The Attorney General states that she's not a registered or licensed person. The federal offices told me not to be in business with them.
Ma'am,
yep.
I'm going to tell you right now, you've lost me. From
the very beginning, I presented, the first time I came in to see you, I presented both pieces of paper.
Stop for a moment.
Okay.
I had them pull a small claims case involving yourself against Bell Management.
Yeah, they did things that were illegal. Fair housing.
Ma'am, That was over a year ago. I would like to say I absolutely remember that,
Yeah.
but I don't.
I'm in dismay myself, sir, because I made that agreement with you. I clearly don't allow a judge or myself to be taken advantage of by an attorney's office.
Well, I don't know that I've been taken advantage of.
I believe I have been.
Okay.
I would
that's
not
fine.
enter your courts to present this witness information as very
Ma'am,
imperative.
stop for one moment.
Okay.
Let me hear, I've heard from you for a while. Let me hear from the other side.
Okay.
Mr. Callahan.
Thank you, Judge. Kevin Callahan, P78273, representing Bell Asset Management. The matter that Ms. Malik is speaking of was a previous matter, a small claims matter that was filed against my client in conjunction with a non-payment of rent matter that we filed against Ms. Malik. Those matters have been decided. Those matters are closed. It has no bearing on this matter whatsoever. This current case, Ms. Malik even admitted she's on a month-to-month tenancy. We provided a 30-day notice to Ms. Malik. She never showed up to court, so a default judgment was entered back in October against Ms. Malik. We subsequently filed a writ of eviction. That writ was signed by Your Honor, and now we get this motion to set aside that default 2 months after the default was entered, alleging that no attorney present and it was against her rights. And I'm as lost as you are with this, Judge. There's no basis to set this judgment aside. Ms. Malik is a month-to-month tenant. She has to vacate the property. However, I will say for the record, because I'm not going to let my reputation possibly be besmirched on the record here of doing anything illegal or improper, Ms. Malik has called my office and left over 120 voicemails accusing me of crimes under the federal law that don't exist, made threats against me, my family. Ms. Malik, I allowed you to speak. Please allow me to speak. She's made threats against my bar license. She's made threats against my family. She's made threats against my office staff. It has been deplorable what my staff has gone through with Ms. Malik over a situation that is a simple month-to-month termination, and Ms. Malik refuses to leave the property, Judge. We're just asking for that judgment to stand and the writ to stand so that my client can move forward.
Leave the property. I never made any threats to anybody's family. I never made any threats to anybody. I did call the office. I asked him for the sheet of paper that he promised. He said he would give me a month to month after August. I said, what is going on? I said, give me the oral confirmation or the written confirmation, and I'm going to continue to pay the money from August onward. I asked your court, I said, may I please have the sheet of paper?
Ma'am.
I did not threaten anybody.
Okay, fine. I don't know anything about that. And I'm not.
If he made an agreement about a month to month, why am I?
Ma'am, you have interrupted me numerous times.
I'm sorry.
That needs to stop.
I did not threaten anybody.
Okay.
Okay.
Fine. You know, always two sides to the story.
Rude.
But the reality here is you're before the court challenging, you're asking me to set aside a judgment to stay the writ.
She then told me, she flip-flopped with me 3 times. She put another sheet of paper underneath my door, asking me, E.J. Jefferson. She
Ma'am,
asked me if I abandoned my unit. Then she tried to take the money out.
Ma'am,
3
okay,
times
ma'am,
in September
you know what I'm gonna do, ma'am? Here's what I'm gonna do.
But there was no order.
Ma'am, I'm gonna pass
She
the matter.
asked me to move out.
Quit interrupting me.
Yeah, she's still
Quit
trying to take the money.
interrupting me. That's warning 2. On the 3rd one, I act. You're before the court to set aside the judgment and the writ.
Yes.
So that the record is clear, The judgment was entered for failure to appear at 2 hearings. First one being October 6th, and then on October 20th. I issued of 2023. I issued the judgment.
Because I thought that the month-to-month would be honored. That's all. That's all that he gave me. It was all the information I went by, was what I was sworn in. When I'm underneath oath, an agreement is made, nothing happened other than me calling his office and asking for that sheet of paper. I diligently, respectfully, and responsibly,
Ma'am, you can have a seat before I find you in contempt. That is now the 3rd time that you have interrupted. Have a seat. Okay. Got one more. We'll call this back. Court recalls the case Bell Asset Management versus Melee.
And for the record, Judge, again, Kevin Callahan for plaintiff, P78273.
State your name again, Miss Melee.
Danette Mellick.
All right. Let me, before anybody else says anything, because this is going way far afield. The only issue before me is the order that I issued in October, which was the judgment, and then the writ of eviction.
Well, I failed the October. I don't know how. I got confused. I'm not accustomed to the courts.
Ma'am, but if at any given time, here's what the problem for you, Miss Ma'am, and I'm just going to be blunt about it. That judgment went out from the court shortly after my signing. All right.
Sir, may I ask something of you? Once an agreement is made in court, isn't that you respectfully gave me the month-to-month. He told me if I dropped the charges on his group, his client would agree to give me a month-to-month. I mean,
then you're going to have to file a new claim that alleges that. That's not before me.
That's why I motioned in August.
No, but that is not before me today.
This is how I will state it.
No,
wait.
you won't.
That's
not before me.
I can pay the money. There was never a failure. I swear I had the money aside.
They want you out.
I didn't.
It's not about the money.
They asked me to pay. There was no probable cause in any level. I called his office respectfully. I asked him for the sheet of paper for the month-to-month that was agreed upon after August. She put a renewal underneath my door. If she wanted me to leave, why was she sending me a renewal? She tried to take the money out in September and October. That would mean I'm still on a month-to-month. I just said, where is the paperwork to confirm that? My bank has it on the record, JP Morgan Chase, September and October.
Ma'am, they want you out.
But she asked me to renew.
Ma'am, I don't know about any of those conversations. They have properly been granted a judgment for possession. They properly filed the writ or the order of eviction. I've signed the order of eviction. There is no basis, and I've listened to everything you said to me. There is no basis for this court to set aside that judgment or to stay the execution of the order of eviction or the writ of restitution. There's no legal basis for me.
I can't pay the money that was agreed upon?
They don't want the money.
Even though she tried to take it out in September and October.
This is a termination of tenancy case. I don't know anything that they've done regarding taking it out. This is
They did.
termination.
They tried to take the money out.
Okay, ma'am, that's fine. I don't know that. But even if that were true, The judgment in this
What did
case,
I have not done anything though, Your Honor. I mean, this is against the law.
no, what would be against the law is me to grant your relief you're requesting. Because they, like you have rights, they have rights. You brought this before the court. And I'm going to say it again to you, so hopefully it'll sink in. They properly got a judgment. Upon properly getting that judgment, they properly requested an order of eviction. I issued the order of eviction. That order of eviction, the judgment, because you have not provided a basis, that will stand. Your motion.
I did nothing after August other than oblige where a month to month was concerned. That was the agreement. I did not refuse payment. There was no probable cause. She put a renewal underneath my door. I says, well, where's the sheet of paper if you're trying to renew? And then she's flip-flopping back and forth with me. Well, I'm like, okay, I thought I was supposed to be on a month to month. That's all it was. She lied to me. And then she lied to me again. And then she tried to take the money out 3 times. So it got me confused. I'm like, well, then am I on a month to month? The bank has that on record. So I came in thinking that if I spoke the truth, because I was sworn in last year and it was agreed upon that I'd be on a month to month after August. That was it. It was as simple as that. I contacted your courts on numerous occasions prior to the end of August.
Ma'am, maybe you don't understand. I just issued my ruling. Your motion is denied. What I will indicate is that the escrow will be held for 15 days and then it will be released back to the defendant. I will not pay the escrow over to the plaintiff. It will be released back to the defendant in this case. Thank you.
So what is the
Thank you,
time
Judge.
frame? May I have till the end of January, sir?
Ma'am, you're operating on borrowed time. I signed the writ
I cannot just,
December 3rd. I signed the writ December 3rd.
to have a moving truck in, please, sir. I mean, it is the dead of winter. I have no problem moving out. I've been looking for another place because I don't trust the people. First, they're making an agreement with me and then they're flip-flopping. Could you please, a little courtesy where this is concerned, please?
You've not granted me any courtesy in terms of your talking. Why should I grant you any? But despite that, the writ will not execute prior to January 16th. So I will give you that grace of 10 days, and if I hear anything else, I may take that.
So I have to be out of this place by January 16th?
They cannot execute the writ prior to that date
Okay,
because otherwise they could do it tomorrow.
right.
I am giving that 10-day, I'm giving you that period. I'm not giving you to the end of the month. I'm giving you that period. That's as far as I'm going. I'm done.
I don't know what I did, and I feel swindled.
Judge, should I enter a order to that effect or will the court?
Yes,
produce the order?
sir. Please.
Okay, thank you. I will
Prepare an
email.
order under the 7-day rule, please.
I'll do that.
Thank
Thank you,
you.
Judge. Have a great day.